The area of indigenous cultural heritage and traditional knowledge and its protection and development is a rich and complex field. Especially important is the question as to whether and how the protocols of the traditional knowledge holders are respected and how the rights of indigenous peoples in this area can be guaranteed. We discussed some aspects of traditional knowledge protection under Module 3. This section will mainly focus on why traditional knowledge is a human rights issue and what the efforts are to create international norms for the protection of traditional knowledge of indigenous peoples and local communities at the World Intellectual Property Organization since the year 2000. ITK, International Indigenous Traditional Knowledge, is part of indigenous peoples' intangible cultural heritage and part of indigenous peoples' cultural rights. It is testimony of cultural and historic continuity and repository of wisdom from past generations onto new ones. Cultural heritage and traditional knowledge is part of indigenous peoples' identity and human dignity. The issue of indigenous peoples has been that their traditional knowledge has been exploited and patented, often by powerful pharmaceuticals and other corporations, erasing the indigenous communities that produced such knowledge into invisibility. Protection of cultural heritage is especially important for groups fighting discrimination. It's a human rights issue, an issue of dignity. This means that the protection of traditional knowledge must go beyond existing intellectual property regimes, legal systems, intellectual property regimes as they are called, namely copyright and trademark actions, which are mainly economic in nature. Some questions that arise are: what protection can indigenous peoples draw from current intellectual property regimes? And what are the limits of these regimes? What are the challenges for traditional knowledge holders? What does a human rights approach to protection of cultural heritage offer? Who should enjoy the exclusive right to commercially exploit intangible traditional know-how and creativity? To whom does traditional knowledge belong? To a group, to individuals, to both? Different terms or working definitions of traditional knowledge coexist. There is consensus that any understanding of traditional knowledge requires being holistic and comprehensive. While including the idea of culture coming from the past, traditional knowledge is also understood as a body of culture that is developing in the present. It is not frozen in the past. Legal custom and institutions are considered part of indigenous heritage and traditional knowledge. The following are UNESCO's elements towards a working definition of traditional knowledge. Quote, traditional knowledge is a cumulative body of knowledge, know-how, practices, and representations maintained and developed by peoples with extended histories of interaction with the natural environment. These sophisticated sets of understandings, interpretations, and meanings are part and parcel of a cultural complex that encompasses language, naming and classification systems, resource use practices, ritual, spirituality, and worldviews. There are huge trade and economic interests of states and the private sector involved in traditional knowledge. Suffice it to say that close to 15 intergovernmental entities deal with traditional knowledge issues from a normative and commercial perspective. The 2004 UNDP Human Development Report, devoted to cultural diversity, pointed out that cultural products and creative activities, if left to the market, could wither and diversity could decline. The evidence of misappropriation of traditional knowledge is shocking. The above-mentioned UNDP report quotes a year 2000 study concluding that 7,000 patents had been granted for the unauthorized use of traditional knowledge, including misappropriation of medicinal plants. The report considers 3 measures as essential. A, the explicit recognition of indigenous peoples' rights over their physical and intellectual property. B, requiring consultations with indigenous communities and their participation for the use of any resource, thus ensuring informed consent. And C, empowering communities by developing strategies to share benefits. For indigenous peoples, the protection of their traditional knowledge is a human rights issue. Let us recall that Article 27 of the Universal Declaration of Human Rights in paragraph 2 states that everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. The UN Declaration on the Rights of Indigenous Peoples clearly highlights the human rights norms that must inform the actions of the state as well as the private sector. Article 31 reads as follows. Indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expressions, as well as the manifestations of their sciences, technologies, and cultures, including human and genetic resources, seeds, medicines, knowledge of the properties of fauna and flora, oral traditions, literatures, designs, sports and traditional games, and visual and performing arts. They also have the right to maintain, control, protect, and develop their intellectual property over such cultural heritage, traditional knowledge, and traditional cultural expressions. Indigenous peoples have been participating in international debates about the protection of traditional knowledge through the processes of the Convention on Biological Diversity and Climate Change, as well as at the World Intellectual Property Organization. Why are the current intellectual property regimes, legal systems, inadequate for indigenous peoples? Intellectual property regimes are legal systems recognizing monopolies in expressions of human creativity in terms of their commercial exploitation. They protect the rights of the individual creator. However, there are limitations in such protection. Whatever the type of intellectual property protection, the protected creation will always end up in the public domain. In other words, in the public commons, the body of all the creative work to which no exclusive intellectual property rights apply. This is an issue for indigenous peoples, since their traditional knowledge, which has often been exploited by others, is the product of their cultures and communities over a long period of time, and there is no specific person identifiable as the creator of such knowledge. Moreover, given the misappropriation of their traditional knowledge by powerful corporations, there is an inequality in any attempt indigenous peoples' communities may make to establish their ownership of traditional knowledge in courts, not least courts in foreign countries against such corporations. To respond to this and related issues, the World Intellectual Property Organization, WIPO, established the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore in the year 2000 without defining the term. WIPO has underlined the complex nature of traditional knowledge that encompasses the forms of traditional know-how, innovations, information, practices, skills, and learning of traditional knowledge, such as traditional agriculture, environmental, or medicinal knowledge. Since 2000, WIPO's Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore has been discussing the relationship between intellectual property and the rights and interests of indigenous and local communities. The debates point to the need for a multi-pronged approach that would combine intellectual property protection, non-proprietary and non-intellectual property measures, and legal customary systems, the latter being of particular significance for indigenous peoples. The outstanding questions for indigenous peoples are A, the respect of free, prior, and informed consent, B, benefit sharing, and C, the challenge of traditional knowledge entering the public domain. The fact that as of 2020, there has not been an outcome at WIPO in terms of an international agreement is a continuing demonstration of the tremendous economic value of traditional knowledge, the desire of powerful corporations and states where they are based to continue to benefit from traditional knowledge, and the resistance of the latter to recognize rights to indigenous peoples and local communities who are creators of such knowledge.